you. Thanks, Jack. So I am going to give you an employment law update, a quick recap on changes we've dealt with recently, and then we'll launch into the Employment Rights Act 2025. So going back to April 24, these were some changes that you probably have been dealing with in your business the last year. So we had carers leave introduced, and you may have dealt with the first wave of usage of that, hopefully have a policy which is in line with your other family leave policies. We've got flexible working that become a day one right, and you may have seen more requests for flexible working and a greater expectation that they will be accommodated. You may have experienced some tensions between the operational needs of the business and employee retention. And then the increased protection period for people who are pregnant or returning from maternity leave. If you've had a redundancy process, you would need to have applied that protection period to your redundancy process correctly. So then last year, we saw the introduction of the Neonatal Care Leave and Pay Act. We'll talk more about that in a minute. The ACAS early conciliation period was increased from 6 weeks to 12 weeks from December last year, just simply because ACAS was struggling to cope with demand. That is temporary. They're going to review that in October and see if it needs to stay there or if it needs to come back down to 6 weeks. And then, of course, the Employment Rights Act, which became law at the end of the year last year. So Neonatal Care Leave and Pay Act, this came in April last year. 2 separate rights, the right to leave, which is a day one right. And then if people have been there 26 weeks, they're entitled to some pay for that leave. There's an average weekly earnings limit. If they're earning over that, they can get the rate at the statutory rate or 90% of earnings. You could, of course, as a company also offer a benefit and pay that at full pay. The usual employment protections, the right to return back to the same role after they've taken that leave, and obviously to not be dismissed or suffer a detriment because they're seeking to take that leave or have taken that leave. So hopefully you've introduced a policy to comply with the scheme and understand the 2 tiers of leave. So you've got the immediate need to take leave when the baby is receiving neonatal care immediately after birth, and then maybe later on the baby is having to have care and the parents need to have leave then. Updating your records to record this and obviously pay it at the correct rates. Training for managers and HR to deal with requests, how to deal with those requests, deal with them sensitively, and avoid those detriment, dismissal and redundancy pitfalls that I mentioned.
Can I ask a question?
Yes.
That does relate to mother and father?
Yes, parents, yeah, so both parents, yes. So then we got the Employment Rights Act, which was finally received royal assent on the 18th of December last year after lots of to-ing and fro-ing between the House of Commons and the House of Lords. And this is a key pillar of the government's plan to make work pay. The changes are going to come in over 2 years, so that gives you plenty of time to plan and prepare for these changes. And we've got the government roadmap which sets out when we can expect those changes to take place. Lots of those changes are subject to regulations, so we know what they're proposing, but what we haven't seen yet for lots of things is the actual draft regulations. So we will see in then more detail about what they will look like. And they're also subject to, lots of things are subject to consultation, so things may change. So changes, so we've actually had a change already. Changes to paternity leave, so it's a day one right if sadly the mother or the other adoptive parent dies. That was from December last year. I'm not going to talk about any changes to trade union legislation at all, so if you want to talk about that, I'm happy to have a conversation afterwards. So a quick run through of what we can expect in April this year. We've got changes to paternity leave and ordinary parental leave. So paternity leave is going to become a day one right. Currently you need 26 weeks service to be entitled to that. And then ordinary parental leave will become a day one right as well. Currently you need 1 year to be eligible for that.
What's the difference between paternity leave and the ordinary parental leave?
Different types of leave, and there's also shared parental leave as well. So there's lots of different leave that parents are entitled to. Paternity leave is your 2 weeks pay. Ordinary parental leave and shared parental leave are other types of leave as well. And they're changing the law as well, so you can take one after the other. So you can take paternity leave after shared parental leave as well. There's going to be a greater entitlement to sick pay. I'll talk about that in more detail in a minute. Where there's been a failure to collectively consult, there is an increase in the protective award from 90 days pay to 180 days pay. People that report sexual harassment should be treated as whistleblowers, so they have that protection, not dissimilar to the protection they have now. So if people report sexual harassment, that's sort of a type of discrimination and they're protected from victimisation in any event. So that's not much of a change. We've got the voluntary gender and menopause pay gap and action plans that companies need to bring in, and that's going to be mandatory from 2027 for companies with more than 250 employees. And the Fair Work Agency is going to be established, bringing together existing enforcement bodies under one roof. But I think the key thing here is going to be how well it's going to be funded, because if it doesn't have the funding, it probably won't be that effective. So we'll keep an eye on that. Then looking forward to October 26, we've got fire and rehire to become automatically unfair. I'll talk about that in more detail shortly. Employers will be liable for harassment from third parties. So employers will need to identify the risk of where are staff likely to be exposed to harassment from third parties, identify those risks and take steps to prevent it. Employers will need to also take all reasonable steps to prevent sexual harassment in the workplace. There's going to be changes to non-disclosure agreements, otherwise settlement agreements that we commonly call them. I'm not sure this one is going to happen. It's basically saying that if anybody has alleged discrimination, harassment type claims, they won't be allowed to be silenced. So any clauses that seeks to silence them on talking about that discrimination harassment will be void. However, that kind of goes against the whole idea behind settlement agreements of bringing those claims to an end and not talking about them. There's going to be some changes to tipping law, so there will be a duty on employers to consult with workers or representatives before bringing a policy in and to update it every 3 years. Time limits at the moment for bringing claims for most claims is 6 months, 3 months rather, but it's going to be increased to 6 months for all claims. So that's the time that people will have from either being dismissed or something happening at work, the time in which they need to contact ACAS and notify them of their intention to bring a claim. So looking forward to next year, we've got the reform of unfair dismissal, twofold, the reduction in the service period that you need to have to qualify for unfair dismissal, and quite out of the blue was the removal of the statutory cap. We'll talk about those two things in more detail. We've got the increased pregnancy, maternity and paternity rights, increased protections for people on maternity leave or are pregnant, and paternity leave, we're thinking that's going to increase to 52 weeks to bring that in line with maternity leave, with also a right to take kit days as well. Bereavement leave will become a statutory right. We don't know if it's going to be paid or unpaid, but of course, as a company, you can choose to pay that as a benefit. 0 hours contracts, they're proposing that workers will be entitled to ask for guaranteed hours. Again, this is going to need a lot of regulations to amend that law, so we'll need to see what those regulations look like. Flexible working, it's already probably what most of you are doing if you deal with a request, in that you give the reasons why you're refusing it and why that refusal is reasonable. That will become a statutory requirement. And rules around collective redundancy, at the moment you just need to look at individual workplaces, and when you're looking at the limits of 20 or more employees in 90 days, from 2027 it'll be across the whole workforce as a whole. Statutory sick pay, so that's coming in from April this year. It's an entitlement to sick pay from the first day somebody is off sick. At the moment, there's a wait period of 3 days, so statutory sick pay is only payable from day 4. There's no lower earnings limit, so this means it's available to many more workers and employees who are on lower earnings. and that's paid at the usual of the 80% of earnings or the flat rate. So you need to identify where the right to statutory sick pay is. Is it in your contracts? Is it in your policies? And you need to update those. And also think about your company sick pay. What does that do at the moment? Do you follow statutory sick pay? Do you have a wait period? Are you going to also pay that from day one? If you have lots of short-term absences, you're probably going to want to manage those more proactively. It's going to be an increased cost to the business. This is not recoverable as many of the other statutory payments are. So you will really want to think about how you manage your absences going forward to get those down, to get that cost down. Fire and rehire. So this is coming in October. It's quite a big change. Only less than 1% of employers use this tactic. It's not commonly used, but when it is used, it's high-profile cases such as the P&O case, which I think is where the pressure has come from to change the law. However, this is going to have quite wide-reaching implications for businesses. So it's going to become law that it's automatically unfair to dismiss somebody for refusing to agree to a restricted variation of contract in order to replace or rehire under a contract, including a restricted variation, or to replace them with someone who's not an employee. And a restricted variation of contract is as expected: pay, hours, pensions, etc. Probably not description or location, but it's going to be most other terms that makes up their packages. Currently, if you are looking to change T's and C's and you consult and you get to the end of that process and people aren't in agreement, you can end that contract and issue them with a new one with the change in it. But you won't be able to do that any longer. Employees will be able to say, no, I don't agree to it, and there's going to be very little that you can do. There is an exception where if the business is in extreme financial difficulties, they have no choice but to make the change, but that really is quite severe, probably not going to be widely relied upon. It really comes down to can the business continue to operate or not. So companies are going to look to rely on variation clauses more widely. Obviously, these can't be too widely drafted so as to create uncertainty in the contract, but you would want to look at your contracts, make sure they're carefully drafted to allow those changes to be made. Will also probably have an impact on redundancies. So if you're making redundancies and you identify through consulting with your employees an alternative to redundancies, being a pay cut or a ban on overtime, if that needs a change to your contracts, you could have employees vetoing that by not agreeing, and there won't be much you can do. So that's quite a big change.
Quick question. How does it work when you're saying about a variation in a contract that the employee can refuse it? What if you're putting this in because of new legislation to say this is guidance from yourselves or from somebody else to say we should put this in your contract, and then they refuse it? Does that mean it's irrelevant to them, or does it mean they're covered by it because it's the law?
Yeah, well, yeah, because it's the law, exactly. But I mean, I think we're talking about pay, pension contributions, their holiday entitlements. So it's really sort of like the specifics to them, the T's and C's of their contracts. So the wider things like statutory sick pay and stuff, yes, you would say the law is changing, so we're making a change to your contracts. But this is really the reason why they're going to work, their holiday entitlement, how much you're paying into their pension, so that kind of thing. Yeah, exactly, yeah. Their T's and C's of their employment, yeah. So this got a lot of press attention. The unfair dismissal reform was one of the headlines when they first brought in the Employment Rights Bill. So it was going to be a day one right. So it was going to be a day one right to claim unfair dismissal. A compromise was reached, and it's now going to be 6 months. Well, we know it's going to be the 1st of January because when they announced the compromise, they also said it's going to be from the 1st of January. It's worth looking back. Historically, it's always been between 6 months and 2 years. So the limit for service was brought in 1971, and it was 2 years then. Quite quickly in 1974, it was reduced right down to 6 months. And then from 1979 to date, it swung between a year or 2 years, generally with the Conservatives preferring the longer period and Labour the shorter. And obviously, if the government changes, then we may see it change again. But the plan is that from the 1st of January, anybody that has 6 months service will be able to claim unfair dismissal. It feels retrospective, but it isn't. It's just a factual thing. So on the 1st of January, so that's people you're hiring now, they will have the right to bring an unfair dismissal claim. It's worth noting that there's many claims that can be brought without a period of service, automatic unfair dismissal claims, around 20 of them, things like discrimination where you don't need any length of service at all. Out of the blue as well, they decided to remove the statutory cap. So we have a limit on what people can claim for their unfair dismissal damages in the tribunal, which is currently the lower of the statutory cap, which is about 118,000 or 52 weeks' pay. So the history with that one, so before 1999 it was £12,000, which had just become completely eroded by inflation. In 1999 they raised it to £50,000 and linked that to the retail price index, and then in 2013 we have what we have now. Was introduced with the lower of a statutory cap that's set each year, and then or 52 weeks pay. So which is ever is the lower, that's the limit on what somebody can claim. And it's all losses. So if this cap is lifted, and it's subject to consultation, so that may change. If that cap is lifted, then it may become a more appropriate or attractive forum for higher earners to use the employment tribunals. Currently, high earners with big pensions, shares, bonuses, very often their losses can run into the millions, and they just don't bother using the employment tribunal because there is a cap on what they can achieve. They may decide actually to use the employment tribunal, which is a worry because the employment tribunal can't cope with what it's dealing with at the moment. The backlogs are quite significant, so that is a concern. And actually, I think once they've consulted on it, I think actually they will bring in either back the statutory cap or 52 weeks pay, but we'll wait and see what happens with that. I think the changes to the service requirement for unfair dismissal are positive. It's quite a change from 2 years to 6 months. However, it does bring us in line with our European neighbours and aligns us with modern labour markets. It will also promote earlier procedural fairness and action from employees. Very often we get calls, somebody's approaching 2 years, they probably should have been dealt with before they got to that point, but everybody has the comfort at the moment of 2 years, so they kind of maybe let things slip. But this will really promote from the start, diarising those dates, having those regular check-ins with staff, setting clearer expectations, and ultimately will improve employee retention because they have job security earlier, and you will be setting out those clearer expectations from the start, which will really professionalise your business and how you're dealing with your staff. I think we're going to see less vexatious discrimination claims. We all know that if somebody is dismissed before 2 years' service, they can't bring an unfair dismissal claim, so they bring a discrimination claim. They are difficult to deal with. There's preliminary hearings. They're normally listed for a week or more. It costs a lot of money to get one of those struck out once it's issued in the employment tribunal. We may see an increase in unfair dismissal claims, but they are much easier to deal with. Cost-wise, they're normally just listed for half a day or a day quite quickly, no need for preliminary hearings, and a lot cheaper for an employer to deal with in the tribunal. So how can we help you prepare, and what really should you be looking to do to prepare for all these changes? So I think you really need to have a dedicated implementation work stream and treat this as like a change programme in your organisation because the changes are so vast. I need to review your workforce, make sure you identify everybody's status. Have you got it right? Worker, employees, contractors. You then need to look at your contracts and policies, audit those. We can help you with that as well. Have you got them right? Bearing in mind you probably won't be able to change them in the future. And your policies, have you got a good set of policies there? We can help you by updating those documents or if need be, preparing new ones. We can support you with your processes. So if you need to go through a redundancy, a restructure, capability, disciplinary processes, we can help you. Have a chat with us early on. We can demonstrate the support we can give you. We can draft you meeting scripts so you feel confident going into have those difficult conversations with staff, the letters and advice, obviously, as the process unfolds. We can provide training with all these changes, with helping you to introduce these policies in your organisation. We also have the Phillips Employment Law Protection Scheme. So that's market-leading legal expenses insurance that can protect your business from employment tribunal claims. Crucially, it kicks in from the point at which an employee notifies ACAS of their intention to bring a claim, and it would cover your business for all the legal costs, and you can use Phillips, so you can use the people that you have that relationship with already, who understand your business, and it covers you not just for your legal expenses, but also any awards or settlements that you have to pay as well. So it really can fix the costs for your business.
Sarah, is that a before the event policy or can
Before the event insurance, yeah.
can't buy after the event?
No. Unfortunately not, no. Before the event insurance, yes. So 3 key takeaways from today. We have the government's roadmap on how they're going to introduce the Employment Rights Act changes. So we really do have some time to plan and prepare, which is what we need to be doing. We need to be digging out those contracts, policies, processes, and reviewing those and making sure that they are ready, identify any risk areas and deal with those. We need to make sure that you're documenting your decisions so you can make sure that they are being dealt with consistently. If you think that somebody will have 6 months potentially to bring a claim in the employment tribunal, a 12-week early conciliation period, that's 9 months, and then a month after they've got their certificate to bring a claim. By the time you know about a claim, it's probably going to be almost a year later. And then you're going to be looking back in their file to try and understand what happened. People may have left. I don't think anybody's memory is that good to remember what happened a year ago and the conversations you had with someone. Yes. Yes.
Generally, that's to get a resolution between the employees.
Yes.
So you will know when a claim's been put
Yeah.
to ACAS, won't
Yeah,
you?
absolutely. Absolutely. Yeah. You would know. You would be aware of it,
Yeah.
but you wouldn't actually know the detail of their claim until they've put it in the employment tribunal and you've got their full pleadings. So obviously with ACAS, ACAS try and understand what is the claim about,
Yes.
but they don't go it because very often they'll say, oh, it's discrimination, it's this or that. But then by the time you get to them issuing the claim, they may have chucked in failure to make reasonable adjustments or failure to deal with my flexible working request or all the other elements of their claim that your defence will be, what policy did we follow, what process did we follow, how was that recorded? So you won't really know the details until you get to the tribunal stage. But yeah, you'll be aware of it, absolutely. You need to review your workforce structure, and if you have any future change plans on the horizon, have a look at those now, identify what risks the Employment Rights Act will expose your business to. So the main takeaway really for me is you need to plan, prepare and be ready for these changes. Any questions? Yes, Jill?
Would you advocate increasing probationary periods to 6 months if they're 3 months currently in your business?
I mean, probationary periods can be any length of time, but you just want to think about how that is going to fit with the right to claim unfair dismissal from 6 months. So you probably wouldn't want a probationary period to be 6 months. You might want it to be shorter, or certainly be making a decision within that 6 months, not leaving it right till the point of 6 months.
I've got a very brief question.
Yes.
This is sort of hybrid of both of your...
Fabulous.
So if I'm looking to sell my business,
Yeah.
now, for example, you've obviously got all the employment law rules about, so you might want to gear the earner so you're not paid very much for tax reasons, whatever reason it may be, or the buyer might want to save national insurance contributions and all that sort of stuff with the employment side. So do you still have to observe minimum wage for that employment contract?
Yes.
Yeah. Okay.
And what you sometimes see in transactions, particularly where you've got 2 people owning a business who they've been taking a salary of £8,400 and the rest of the company's dividend equivalents, You then get some of our fellow professionals in London who get very excited about the national minimum wage risk for the owners who are selling, and they will insist on having an indemnity in case your company's ever investigated and there's suddenly an embarrassment about national minimum wage. But if it's you as the sort of owners, I think that's quite low risk, but it can get, you've lived with it and destroy quite a lot of the SME market of how people pay themselves. But yeah, I think making sure everyone's on national minimum wage is really important, because it also depends who.
It's post-sale rather than before sale.
Yeah, but it's who you sell to as well.
Yeah.
Because we recently sold to some of the national brand business, they're going to be much more worried about the PR than if you're selling to someone else. It always will depend on the context of the transaction.
Sarah, can I just ask a question for you on innovations?
Yes, Mandy.
I know we've spoken about this before. If we put them in as 6 months and we have the review a week before their official 6-month date, we're still out of the 6-month period.
But so when you are looking at unfair dismissal claims, you add on statutory notice to get to their effective date of termination. So if you're dismissing somebody within the week of their 6-month anniversary, adding on their statutory notice period will get them to 6 months, and they will be able to bring an unfair dismissal claim. So it's a really good point because probationary periods are normally 6 months, but you need to be thinking it needs to be at least a week before their 6-month anniversary.
Okay, brilliant. Thank you.
Sarah, with
Yes.
the Liverpool's gap in action plan, what's
Yeah.
the reporting period for that? Is that when you start, you've got to report by, well, you tell me.
I don't know. I'll have to look it up. I will look it up and let you know. Yeah, but that's voluntary at the moment, mandatory in 2027. Any other questions? No?
There's a lot
Lot to think about.
And it's my bit you get to choose on. Sarah's bit you
You
really
don't have any choice. Well, thank you all for coming. Brilliant to see you all, especially given the weather. Do stay around. We're going to have some more teas and coffees outside. They're also going to be giving tours of this wonderful place. It's beautiful, so do stay around for a tour and see what facilities they have. Go and have a look at the paddle courts as well. But thank you very much for coming. Thank you.